Hi everybody, it's me again, and I'm here with the lecture for you for assignments number 29 and number 30, in which we will talk about the Dormant Commerce Clause. So with the Dormant Commerce Clause, we're really talking about the flip side of the federalism issues that we have been discussing so far in this class. To date, as we considered the tug and pull of federalism, we were considering mostly how the court is recognizing and trying to respect areas where the state has authority to legislate and using that authority as a limitation on the things that the federal government is able to do. With the Dormant Commerce Clause, we are flipping those two things around, and we see the court taking a recognition of and paying respect to the powers that the federal government has and using that acknowledgement of those powers as a limitation on the things that the states can do, on state power. Now, I'm going to start out this discussion by being frank with you, which is that I personally think that constitutional law is pretty awesome. It's super interesting, and there are so many different aspects of it that I absolutely love to talk to you about. In my humble opinion, the Dormant Commerce Clause is not the most interesting part of constitutional law, but I will say that it is perhaps the most heavily litigated form of constitutional law, and it is really important. Particularly if you end up someday litigating or practicing in a field where you are relying on or affected by a variety of state laws, whether or not there is a Dormant Commerce Clause issue is something that you're really going to want to be on the lookout for. So on that note, let's get going. As we think about the Dormant Commerce Clause, we're going to be asking two primary questions. First, we're going to consider the question of why there is a Dormant Commerce Clause, and then once we understand the purposes or reasons behind the recognition of a Dormant Commerce Clause, we are going to take a look at how we might know whether or not a state law violates the Dormant Commerce Clause. So the first case I had you read was the H.P. Hood and Sons case from 1939. This case centers around the trade of milk primarily to the city of Boston. Boston at the time got almost all of the milk that the residents purchased from out of state. And in this case, we have a Massachusetts dairy company that applies to build a depot in New York for the purposes of helping them distribute milk that was produced in New York to the people of Boston. And the state of New York says no. It says, we're not going to let you build this depot. Now, why did the state of New York do this? Well, just like when we were talking about the Commerce Clause, I think having a little understanding of what the reasons might be behind the policies that the legislatures are trying to enact can be helpful. And also, just like with the Commerce Clause, I really have no idea how sound these approaches might be as a matter of economic theory. But for one reason or another, the state of New York doesn't want milk that is produced in its state to leave the state. They don't want it shipped to Boston. They have concluded that keeping this milk in state will protect and advance, the court says, their local economic interests. Presumably, they want this milk available for the citizens of New York to be able to purchase, that the prices perhaps will be lower. So Justice Jackson writes the opinion of the court, and he says what the state of New York has done here is unconstitutional. And he tells us it is unconstitutional because it violates something we call the Dormant Commerce Clause. Justice Jackson tells us that the state of New York can definitely regulate the milk trade and other things if they are trying to protect their citizens from things like health hazards or from fraud. But what it can't do is burden the flow of commerce for their own economic advantage. So they can exercise their state police powers to protect the health, safety, and welfare of their citizenry, but they can't promote their own economic advantages by trying to burden interstate commerce. And they can't do this even if Congress, who has the power to regulate interstate commerce here, hasn't acted. They haven't passed relevant legislation to regulate the interstate trade in milk that would affect this case. So we see the court introduce this idea for us that there exists not just the Commerce Clause in the Constitution, but something called the Dormant Commerce Clause. And the Dormant Commerce Clause is this principle, the principle that state and local laws that place an undue burden on interstate commerce are unconstitutional. And they're unconstitutional even where Congress has not yet exercised its Commerce Clause powers. So just to help us distinguish between the Commerce Clause and the Dormant Commerce Clause, to make sure we understand, the Commerce Clause is the provision in the Constitution that empowers Congress to be able to act in regulating the interstate commerce. The Dormant Commerce Clause, on the other hand, is a principle that is not stated explicitly in the Constitution, yet acts as a limitation on what kinds of regulations states and local governments can do that can have an impact on interstate commerce. So if you are taking an exam or one other way, looking at an issue and perhaps you're a little confused about whether you're dealing with a Commerce Clause issue or a Dormant Commerce Clause issue, the key thing to do is to look at which governmental body is trying to do the regulating. So if it's Congress that is trying to pass a law, that's trying to actively regulate something, then it's a potential Commerce Clause issue. But if it's the state or local government that is doing the regulating or attempting to do the regulating, then it's a possible Dormant Commerce Clause issue. And also, as you may have noticed over the readings, if it involves milk, for whatever reason, it's also likely a Dormant Commerce Clause issue. I have no idea why milk is such an issue. All that I know is yet another thing that makes the Dormant Commerce Clause kind of boring. Okay, so I mentioned that the Dormant Commerce Clause, unlike the Commerce Clause, is not mentioned explicitly in the Constitution. So that raises the question of where does this come from? Why does the Supreme Court recognize this limitation on state and local power? And what the court has done is it has inferred this principle from the award of power to regulate interstate commerce to Congress. They have said that even in situations where Congress has not exercised its power to regulate interstate commerce, its power nonetheless that it has to regulate interstate commerce here, so the proper power that it has, this power lies dormant, even when it isn't acting. And as it lies dormant, that means that state and local laws cannot come in and put some kind of undue burden on interstate commerce. It's also sometimes called the negative Commerce Clause. So by giving Congress the power to regulate interstate commerce, the idea is that the negative, the flip side of that, is also true, and that the Constitution does not give the states the power to burden interstate commerce. So instead of focusing on the scope of authority for Congress to act under the Commerce Clause, the Dormant Commerce Clause, as I said, works as a limitation on state and local governments. So as for this question of why the court recognizes the principle of a Dormant Commerce Clause, the book gives us the few primary arguments in favor of it. First is just the historical argument. The argument that the framers and the framing generation intended, it was their intent to centralize the regulation of commerce in the federal government. The goal here was trying to put an end to having interstate trade wars, not necessarily to encourage the federal government to be really hands-on regulating interstate commerce. In fact, they say that this is one of the primary purposes of the Constitution, that there was no federal power that was deemed to be so necessary at the time of ratification, other than to be able to regulate interstate commerce, and that there was no state power that was so readily relinquished, which would be the power to place a burden on interstate commerce. Kind of closely related to the historical argument is an economic argument, but this just makes economic sense, that we need the states to be working together in interstate commerce rather than fighting trade wars against each other. Sort of the whole idea that we sink or swim together, that the kinds of practices where each state was trying to gain an economic advantage as against another state were very detrimental and are very detrimental to our nation as a whole. But as a national economy, we can be far more prosperous if the states are indeed united. The notes in the reading also mention the political representation argument that we talked about when we read the McCulloch versus Maryland case, the case about whether Maryland had the power to tax the national bank. And so you may recall that the argument that Chief Justice Marshall made in that case was that Maryland can't tax the bank because that would put a burden, a tax burden, on the citizens of other states who weren't able to vote against the policymakers, in that case, Maryland legislatures. So we lose out on the political accountability, the political representation, even if Maryland had passed a tax that the people didn't like or that had detrimental effects, there isn't going to be this effective political check on it. Because the people who might be most affected by it aren't the people who can vote. So the argument here is, in the Dormant Commerce Clause, is really the same idea, that we can't have one state that is passing laws that are going to burden the people in another state because the people in those other states don't have any political representation in that state. They can't use the power of their vote in order to push back on this kind of law. Now, not everyone buys these arguments that the court should be recognizing a Dormant Commerce Clause. One of the chief critics of the Dormant Commerce Clause is Justice Thomas. The book includes some excerpts of his arguments against the recognition of a Dormant Commerce Clause. And one of the things I'll hope that we have some time to talk about when we discuss this in our live class meeting is what you think about these arguments, or at least think about these arguments as against the arguments I just mentioned in favor of recognizing a Dormant Commerce Clause. But Justice Thomas, first and foremost, says the court should not be recognizing a Dormant Commerce Clause because there's no textual basis for one. The Commerce Clause in the Constitution authorizes Congress to act, but it does not mention anything about placing some kind of limitations on the state's ability to act. He also argues that recognizing a Dormant Commerce Clause is simply unnecessary because if a state goes too far in one of their laws and places too much of a burden on interstate commerce, then Congress has the power to rectify that situation. They can pass a law that invalidates it. Because under the supremacy law, the federal law would regulating interstate commerce would preempt whatever state law had been enacted in this case. And he points out that we don't allow the concept of a law being preempted through congressional silence in any other area of law, in that we shouldn't recognize it here either. He also argues that this gives courts too much power to decide what kind of states' laws they think perhaps are good laws or policies that they approve of or personally disapprove, because as we will talk about in just a couple of minutes, it's not always clear when we have a state law that is placing an undue burden on interstate commerce, and when we have a state law that is simply the state acting within its rights to protect its citizens under its police power. He's also concerned about overly restricting the power of the states, as we've talked about with the Commerce Clause and the 10th Amendment, that he has a concern about making sure we sufficiently protect state sovereignty and the powers of the states. But despite Justice Thomas's objections, the Dormant Commerce Clause is a part of our current constitutional law, and it has been for about 200 years. But the debate over how strictly the Dormant Commerce Clause should be enforced, or about what the test should be for figuring out when it has been violated, that debate continues. Because we don't want states to be regulating or burdening interstate commerce. We also don't want them to be passing protectionist laws that hurt free trade. And we don't want them to be able to regulate the people or the businesses who aren't able to hold them accountable. But we do want them to be able to exercise the powers that were retained for them in the Constitution and our Federalist system, and to protect their citizens through their police powers. So this takes us to our second question, which is the question of accepting that we have a Dormant Commerce Clause principle that's going to be enforced and that we understand why it's going to be enforced. Then how are we going to know which state laws violate the Dormant Commerce Clause and which do not? And very much like the Commerce Clause power, we have seen the court struggle with drawing this line between acceptable state laws and unconstitutional state laws over history, and they have tried a variety of different approaches to being able to figure this question out about when it's an acceptable law and when it is not an acceptable law. So one of the first approaches that the court attempted can be traced back to the Gibbons case that we read. This was the Chief Justice Marshall case about the Ferry Monopoly in New York Harbor. And in that case, Chief Justice Marshall said that commerce refers to all stages of business that affect more than one state. But he also talked about how the Commerce Clause also is an independent limit on state power, even where Congress has not acted. And he makes this distinction for us between a state when it's exercising its police power to protect its citizens versus state laws that are regulating commerce among the states. So this is the first line we saw the court trying to draw, that we'll know that a law is constitutional because it's an exercise of the state's police powers, and we know that it's unconstitutional if we have a state trying to regulate commerce. This, however, still can be a tricky definition of laws that violate the Dormant Commerce Clause. Even Chief Justice Marshall acknowledged that some state police powers, like laws that are passed properly pursuant to their police powers, can actually have really significant effects on interstate commerce. These might be laws like, inspection laws of goods and foods that are coming into the state, done properly for the state's interest in protecting the health and welfare of its citizens, but nonetheless having a significant effect on interstate commerce. Quarantine laws, which we're becoming increasingly familiar with these days, was another one he mentioned, or just other types of health laws that can technically appropriately fall under the police power, but place these great burdens on interstate commerce. So drawing this kind of line might not accomplish what the reasons behind the recognition of the Dormant Commerce Clause. It might not prevent us from having trade wars and that type of economically disadvantageous policymaking by the states. There are those who argue also that this is not the right way to think about this line because the states should and do have some concurrent power to regulate commerce along with the federal government. So not everything, every law that they have to pass has to be able to fall under the police powers. So I'm just going quickly through some of these earlier approaches. I cut out some of the reading here, but just so you sort of understand the flow of the court's thinking. So a second approach we saw the court taking was trying to draw a line between acceptable constitutional laws by states and unconstitutional laws that violated the Dormant Commerce Clause, based on drawing a line between whether the object of the regulation was a national subject matter or a local subject matter. So this rose out of some cases, one of which involved the state of Pennsylvania, that it wanted to have any ship that was entering into the port of Philadelphia to use a local pilot to guide the ship into the harbor. The state said that their purpose behind this was safety, that this fell in their police powers, but critics of the law said actually this was economic protectionism. They were simply trying to protect jobs for local pilots. And the court tells us, well, the way we're going to think about this is not about whether this is a police power or whether they were trying to regulate commerce. Rather, we're going to make this distinction between things that are a national subject matter and thus require uniform regulation that needs to come from Congress versus things that are a local matter and therefore either requires or it's acceptable to have sort of diverse regulation from states to states. In that particular case, they said that regulating pilots is a local matter. It turned out there were problems with this approach as well, mostly being that state regulations, no matter how minimal they might be or how protectionist and how much they are or how much they might interfere with interstate commerce, were upheld as long as they were deemed to be a local matter. Now, Justice Thomas would have me remind you at this moment to say, of course, Congress could always preempt if we had a state law of a local matter that was deemed to be overly protectionist, but merely as drawing a line between applying or not applying the Dormant Commerce Clause, that didn't seem to be achieving our goals. It also drew a line that could really at times seem almost arbitrary. Really, almost any area, you could argue, would benefit from some kind of national uniformity of regulations and at the same time also benefit from having some kind of local diversity. We also ended up with some sort of nonsensical decisions by the court. In one case, for example, again, that I didn't have you read from 1938, we had South Carolina that imposed a state law that had length and width requirements for trucks that were going to operate in the state. They claimed that they passed this law because they wanted to have safe and economical use of the highways in their state. They wanted to preserve the roadways by not having trucks that were too big. But this kind of law, if every state had a different set of criteria for how long or wide trucks were, imposed a very severe burden on interstate traffic. Truck traffic through every state would have to meet different requirements, and we were really going to hinder interstate traffic. But nonetheless, in the case I just told you, back in 1938, the court said, oh, this is constitutional because regulating state roadways is a local of concern. But it started to become clear that this didn't really make a lot of sense as the way to draw this line. So then we saw the court try a new approach, which was basically to adopt a form of balancing, saying, okay, what we're going to do now is instead we're going to balance the state's interest in passing the law that they have passed against the burden that they are placing on interstate commerce. South Carolina, your state interest in having trucks of be a particular size might be real, but it is not as significant as the burden that you are placing on interstate commerce by forcing trucks to have all of these different, meet all of these different requirements. But balancing also raised its own concern. And in particular, when you give courts the power to balance one legislature's interest in passing a law versus another legislature's potential interests, the concern is that you're opening up an avenue for what is in reality judicial policy making. That the mere act of balancing asks judges to give weight to how important they think the policy interests are behind the law. So we had several justices entering into the sort of modern era here who really objected to using a balancing of interests. In particular, Chief Justice Rehnquist, Justices Scalia and Thomas objected to this kind of balancing approach. In the words of Justice Scalia talking about the balancing of interest in Dormant Commerce Clause jurisprudence, he says, this process is ordinarily called balancing, but the scale analogy is not really appropriate, since the interests on both sides are incommensurate. It is more like judging whether a particular line is longer than a particular rock is heavy. Kind of thing that really makes you miss him sometimes. That's a terrific quote. Okay, so then they started thinking though, so what is it that we are really truly concerned about with the Dormant Commerce Clause? And the justices started to say, really, the more important question is whether or not the law in question is discriminating against out-of-staters. Is it treating people who don't live in the state differently than those who do live in the state? And this leads us then to our fourth approach to thinking about the Dormant Commerce Clause, drawing this line primarily based on this question. Is it a discriminatory law against out-of-staters, or is it not non-discriminatory? Does it treat in-staters and out-of-staters the same way? So you might want to pause and think for a moment about why the court has concluded that this question is so important. Why not just look, as the prior test did, at whether or not interstate commerce is burdened, or weigh how much of a burden it is versus what the state's interests are in having the law passed. And in addition to the concerns about opening the door for judicial policy making, the argument in favor of looking at whether a law is discriminatory or non-discriminatory, the arguments are that this gets us closer to the goals that we set out at the beginning of this lecture, the goals of the Dormant Commerce Clause, which is that we want to promote a national economy, we want to put an end to things like trade wars between the states or tariff busting, and that if a state law treats in-state businesses the same way as it treats out-of-state businesses, or in-state consumers the same way it treats out-of-state consumers, that's a really good signal about whether or not this is an economic protectionist law. It also is responsive to this political representation argument that we talked about. If the law is non-discriminatory and it has the same burden or places the same effect on those who live in the state and do have the right to vote as it does to those outside of the state, we can be a little more confident that the political process might address any missteps the state might make in its legislation. So the current test then really puts together these last two approaches to thinking about the Dormant Commerce Clause. It has a two-step balancing test in which the very first step is to ask whether or not the state law is discriminatory against out-of-staters. This is indeed the crucial determination now, as I was just saying, whether you treat in-staters the same as out-of-staters. Because if it is deemed to be a discriminatory law, then the court is now going to start with the presumption that this is an unconstitutional law. If, however, it is deemed not to be discriminatory, it treats everybody the same, then the presumption is going to be that it is constitutional. Now, Chief Justice Rehnquist, Justice Scalia, Justice Thomas, they would just stop here. they would get rid of our second step altogether. But the rest of the court, at least for now, after getting this presumption of constitutionality or lack of it, then moves on to a second part of the test, in which it balances the benefits of the state versus the burdens on interstate commerce, as we discussed. So if it's found to be a discriminatory law, one of the questions the court is going to ask when it's balancing these benefits is whether or not there are non-discriminatory alternatives that would still preserve whatever these local interests are deemed to be. The second step, part of the step also, if we have a discriminatory law, will then shift the burden to the state to have to establish the importance of its local interest, of its state law. But as I said, a number of justices from the more current court have been highly critical of the second step of this approach. And what we've really seen is that over time, the court has been increasingly relying more heavily on the first step of this test and looking really at the question of whether or not the law is discriminatory or not. This, therefore, makes this question of whether or not a law is determined to be a discriminatory law to be all that much more important. And so what we did see from our readings is how there are different ways a law can be discriminatory. First of all, and most simply, is that the law can be discriminatory on its face. By the very terms of the law, it gives either an advantage to in-staters or a disadvantage to out-of-staters. A law can also be discriminatory because it is determined that it had a discriminatory purpose. Even if on the face of the law, it seems to treat in-staters and out-of-staters the same, if the court concludes that the purpose behind the law was to give some kind of advantage to in-staters or to somehow burden out-of-staters, then it will be found to be a discriminatory law. A law can also be found to be discriminatory if the court concludes that it has a discriminatory effect. So, neutral on the face of the law, but the way the law plays out, the effects that it has on the businesses or people in state versus the effect it tends to have on people or businesses out of state tends to be discriminatory, then we will also consider this to be a discriminatory law. Now, these last two ways, the discriminatory purpose and the discriminatory effect, can often overlap. It can be sort of hard sometimes to peel away whether we have a discriminatory purpose and not a discriminatory effect, or only a discriminatory effect and not a discriminatory purpose. Often it seems the evidence points in the same direction for both of them, but you technically only need to show one of these. Either discriminatory purpose or discriminatory effect will both mean the law is discriminatory. This is different from other areas of law, most notably under the Equal Protection Clause, when considering discrimination, which is something we talk about in Conlaw 2. You have to show both a discriminatory purpose and a discriminatory effect, but in Dormant Commerce Clause laws, you can show one or the other. I had you take a look at a few cases that show this current test in practice. First, we have the City of Philadelphia versus New Jersey case from 1978. This case involved a New Jersey law, and it prohibited the importation of any out-of-state trash. New Jersey was getting rightfully upset at becoming what it felt like was the country's garbage dump, particularly the city of Philadelphia in this cases. They didn't want the city sending them their garbage. They said, affected owners, or this law affected owners of some private landfills who had deals with other cities for waste disposal to be able to collect their waste. They weren't too happy with this particular New Jersey law. So under this test, the court first asked the question of whether or not we have a discriminatory law. And here the answer is yes, it is discriminatory on its face. In-state trash can go to the in-state landfills. Out-of-state trash cannot be sent to New Jersey landfills. So we draw a line at the border. In-state businesses treated one way, out-of-state businesses, customers are being treated another way. So we have a discriminatory law on its face, and it is presumed to be unconstitutional. But the court still goes on to the second step here and engages in the balancing of the benefits to the state versus the burdens on interstate commerce. And this is really where the disagreement is in this case. We have the majority here seeing the balancing as the state of New Jersey helping itself economically and environmentally at the expense of other states. Saying that, if there's less demand for space in the New Jersey landfills, it means the price for in-staters to be able to dispose of their waste will go down, that this is economic protectionism for in-staters at the expense of out-of-staters. At this point, Justice Rehnquist, however, he saw this balancing differently. He thought that the state's interest here was far stronger than what the majority was giving credit for. He said that the state of New Jersey here was simply trying to protect its environment and its public health and safety of its citizens, things that fall squarely under the state's police powers. And then we end with just a couple of cases where we're back to the fascinating world of the interstate market for milk. In the West Lynn Creamery versus Healy case from 1994, we had a state law that put a tax on all milk that was sold by dealers to Massachusetts retailers. But also part of the law meant that said that the proceeds from this tax fund of these taxes that were collected are going to be paid as subsidies to Massachusetts dairy farmers. So the argument here by the state is that this law is not discriminatory. At least it's not discriminatory on its face. Everybody has to pay the tax. So nothing discriminatory is going on, that this would be an acceptable law for under the Dormant Commerce Clause. Then the state of Massachusetts says, the second part of it is different. We have a state right to distribute tax revenue however we want to distribute it. So we want to distribute it only to our Massachusetts, we just happen to want to distribute it to our Massachusetts dairy farmers. So absolutely no problem there either. Court doesn't buy this, says this law is unconstitutional. The court points out that 2/3 of all of this milk is produced out of state, and we have here a discriminatory purpose and really a discriminatory effect. The book says the court's relying on discriminatory purpose, but as I said, there's a lot of overlap. That the impact here is the same as if you were going to have a tax on out-of-staters. Yes, everyone is getting taxed here, both in-staters and out-of-staters, but it's the in-staters who are basically turning around and getting a refund of their tax. So the court says the tax might be constitutional, the subsidy might by itself be constitutional, but together we have a discriminatory tax and also a burden on interstate commerce. And our last example is the Minnesota versus Cloverleaf Creamery Company case. It's now 1981, and the court is considering a law by the state of Minnesota which bans the sale of, yes, milk in plastic disposable containers, but allows paper milk cartons, even if they are also not reusable. So, are we dealing with a law that is discriminatory on its face? The answer here is no. Nothing on the face of the law makes a distinction about whether plastic disposable containers that come from in-state dealers are treated differently or out of state. The whole distinction here is based on the type of container, not about whether we have an in-state or out-of-state seller or buyer. But nonetheless, we have a disagreement about whether or not this is a law that has a discriminatory purpose or discriminatory effect. The state says that the purpose here is not discriminatory. The purpose was to cut down on a solid waste management problem, that they wanted to conserve their natural resources. They wanted to do things like encourage recycling. But some of the milk companies bringing the challenge here say that there is a discriminatory purpose, that the state of Minnesota was actually trying to promote its own economic interests of the local dairy and pulpwood industries, that the state of Minnesota had a substantial paper industry, but it didn't have any kind of plastics industry. And so therefore the effect was going to be a discriminatory one. The effect of this law was that it's going to create more demand for paper products that were traditionally produced in-state, thus giving an advantage to in-state businesses. And it was going to prevent the out-of-state plastics industry from having access to the Minnesota market. The court, however, is not convinced that there was a discriminatory motive or effect. Here they said that the law regulates everyone the same. This is not an example of economic protectionism. They accept Minnesota's argument that the purpose here was an environmental one, that they were acting out of environmental concerns. And they also said that the discriminatory effect is going to be minimal, that there's other uses of plastic in the state. They just targeted sort of this one type of use of plastic. We also see the court going to the second step, balancing of burdens and benefits, and saying that this really isn't causing a very big burden on interstate commerce, whereas on the other hand, that the state interest here is really quite high, that they want to conserve energy, they want to conserve natural resources, they are concerned about the solid waste disposal problem. So the court is convinced and says that this law does not violate the Dormant Commerce Clause. And that brings us to the end of our lecture about the Dormant Commerce Clause, and I will look forward to talking about this all with you on Thursday.